You're watching 13 WMAZ Law Call, sponsored by Macon Law Firm, Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes, and on tonight's show, I have two of Macon's finest attorneys here to answer questions. So let me first of all introduce them. Hello, Mr. Carl Reynolds. How are you, sir?
Hey, Morgan. How are you doing tonight?
Feeling real good, real good. And I see you got your partner with you, Wendell Horn. How you doing?
Got Wendell Horn, who's my partner, also my first cousin, which a lot of people don't know, but we do claim each other.
And he's had to live it down for 30 years, but glad to be here.
Well, it's always good to have both of you around, and it's so necessary tonight because our topic is so very, very serious. We're talking about catastrophic injuries and wrongful deaths, the types of things that changes a person's life forever if they survive. So, sometimes in catastrophic injuries, people do not survive, but the survivors must carry on. So that's why you're here tonight to answer some of those questions. So let's begin with our first email question, which really kind of sets us up here because Roberto wants to know, how do you decide whether or not you will take a case? So Carl, how do you decide?
Well, there are a number of components. I mean, first of all, in any case that involves personal injury or damages, you have to look at the issue of liability. Was somebody at fault? And next, causation. Did that carelessness or fault cause an injury or the damages to the person who has been damaged? So those are the key elements. Was there liability or fault? Was there a causal connection between the fault and what occurred next? And what are the damages? What are the injuries? All these are components of a damage suit, which a lot of people now simply call personal injury lawsuits. I don't subscribe to that myself, but that's basically it. Wendell, you want to add anything to that?
Well, the only thing I would add is oftentimes, Morgan, we see people that have had a catastrophic injury, and there's just not enough insurance to even approach compensating them for the injury. And in a case like that, we don't charge a fee. We look at it and say, y'all can handle this yourself. There's a limited amount of money that's going to be available. You don't need to pay a lawyer to take money out of your pocket.
It's hard to answer that in one segment, but what Wendell is talking about is, are there funds available to pay the value of a catastrophic injury? To give you an easy example, in a medical malpractice case, the injury or the damages to the plaintiff have to be north of $350,000, $400,000 before you can even afford to put the time, effort, and energy into what it takes to bring a medical malpractice case to trial. The same could be said of product liability. It's just an intensive amount of work and effort and energy and cost to the law firm bringing the case. Now, if it's a vehicular collision and you have catastrophic injuries and your defendant is a Coca-Cola company truck or some commercial vehicle, then yes, you've got the pocket, the deep pocket to go against. Then it's really a question of liability and what the damages are.
Okay, so on that note, what happens if you decide not to take their case?
There is no fee
Goes
to
back
begin with.
Let's just say you've got a case that involves $150,000, $200,000 in damages to the plaintiff, and the at-fault driver, and that's the only defendant you have in the case, has a minimum limit policy. When we see those cases, we first of all don't take a fee. We tell them they don't need a lawyer and tell them how to call the insurance company and get a settlement for the amount of the insurance on the car or on the
okay.
And Morgan, I might add, as most people know, the minimum amount of coverage to even be able to drive in Georgia is a $25,000 policy. And I would say a majority of Georgians have a $25,000 only policy. So, that's where you are.
Okay. All right. Well,
let me hastily add also, it brings up one of our favorite topics, which is uninsured motorist insurance. That plays a role in it also. So none of these answers are just pat for every case. You have to look at each case as it is.
Okay. All right. Well, speaking of cases, anything from your recent case files that you would like to share with us today?
Well, if you want to deal with catastrophic injuries, we have been working on one I can share with the audience. It involved a vehicular collision. The plaintiff was driving to work at 4:30 or 5 in the morning. He was working, blue collar man, worked as a mechanic. He was struck from the rear on I-75, knocked across the median and over the guardrail and into the he was going south into the northbound lane, where he was then struck by a tractor trailer truck. He was, I would say, catastrophically injured. He is what we call an incomplete quad, which means he has very limited use of his arms. He can raise one about 5 inches and the other just 2 or 3 inches. He was married at the time. Tragically, his wife has since died, and he has a caretaker, and he has to have a caretaker 24/7. So this has had a tremendous impact on him and his family and his friends. That's one of those kind of cases you just hate to have to handle. But in that case, there are multiple parties involved: the impacting vehicle, the state of Georgia for the way they designed the median and the highway, the company that constructed the barrier that failed to work completely, also the oncoming tractor trailer truck that was involved. They did not avoid him after he was put in a position of danger. So there's so many elements to these things, and they take a great deal of time. We had also another case involved a paraplegic, which is paralysis from the waist down. And that involved a case where the DOT had constructed a work zone and put up those concrete temporary barriers in such a way as to funnel the traffic into that work zone. Well, they also failed to put a flagman or have the law enforcement put a car or a vehicle with flashing lights to warn oncoming traffic. And as this lady sat there, basically caught behind a line of traffic within this zone that had been put up temporarily, a tractor trailer came along and slammed into the back of her car and left her a paraplegic, which of course has been life-altering and life-changing for her and her family. Now, on that case, and I get mad about this when I see advertising on TV, quick settlement. There's nothing quick about any of these cases. The one that I just mentioned about the DOT construction area, it has taken us 1.5 years just to get the records for DOT. Their excuse, of course, is that COVID has kept them from being able to access their computer and get the information that we've requested. A lot of these cases go on for years, 3, 4, 5, 6 years. I think our record has been 7 years from start to a jury verdict and a trial.
Wow. Well, Wendell, what does it cost an attorney to do these types of cases?
Well, usually the injured party who is responsible for the out-of-pocket expenses, meaning the cost of depositions, court filing fees, expert witnesses, in a catastrophic injury situation, that person typically is not able to afford those out-of-pocket expenses. So we advance those expenses as the case goes forward, knowing that that person does not have the funds because they're typically out of work. And at the end of the case, whether it's resolved by a trial and jury verdict or settlement, then we are reimbursed for those out-of-pocket expenses. But they can range anywhere from a couple of thousand, 3,000 or 4,000 in a car wreck case to what, Carl, 150, 200 has been.
Well, the case that I just referenced actually was a product case. Involved a multi-piece rim that exploded and knocked off almost a fourth of a young man's head. He lived, but he lived with greatly diminished capacity. That case took 7 years, and the out-of-pocket cost in it, and I'm not talking about the time of the people working on it, just experts, reconstruction, focus groups. It was a little under $500,000 out of pocket. It was tried in Kentucky. We tried it all the way. It was a 6-week trial. We tried it to a verdict of $19.1 million.
Okay.
But that's an example of how it can be.
All right. Well, I'll tell you what, when we come back, we're going to talk more about money. So you definitely want to stick around for that. Carl Reynolds, Wendell Horn are our attorneys tonight. Catastrophic injuries and wrongful deaths. Well, that's our topic. I'm Morgan Dukes, and you're watching Law Call.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney B.J. Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
Welcome back to Law Call. I'm Morgan Dukes. Our attorneys tonight are Carl Reynolds and Wendell Horn from Reynolds, Horn, and Servant. And we're talking about catastrophic injuries and wrongful deaths. You know, the type of things that truly, truly change your life. And of course, the type of things that you definitely need an attorney for. So we do have some questions, gentlemen, some email questions, and I'd like to get to them. Our first one comes from Jonas. And Jonas wants to know, he says, I've heard that some states place a cap on the amount of money that you can win in a lawsuit. Is that true? And what if the amount of your damages is more than the amount allowed? How should you handle that?
Jonas is absolutely correct. There are a lot of caps in different states. Georgia really doesn't have a cap except on punitive damages. But if your damages exceed the cap, you're just out of luck. You go uncompensated. Typically, most of the caps, though, involve cases that they do allow your loss of income, your medical bills, the pain and suffering seems to be where the caps come in. Wouldn't you say, Carl?
Yeah, Morgan, you know, the three kinds of damages, there are direct expenses, which you call special damages. There are general damages, which basically are pain and suffering caused by an injury done. And then there are punitive damages, which are damages awarded to deter the wrongdoer from future-like conduct. None of the appellate courts in the land like punitive damages, and they're usually not appropriate anyway. But what the question goes to is general damages and that amount of money awarded as compensation for pain and suffering as a result of an injury. And, you know, Georgia years ago tried to pass a bill that limited the amount of damages for pain and suffering. Our Supreme Court struck that down as unconstitutional. There are still states, for instance, we interviewed or reviewed a case in Florida brought by another attorney to us. In North Carolina. In North Carolina, there's a limit of $500,000 for non-economic damages. And again, that's one of those cases falls into the category of you might not be able to take it. Up there, this was an elderly man. He didn't have any income. He was retired. He basically didn't have that much in the way of medical bills. They're allowable. So all he had was the value of his life. And you're looking at a cap of $500,000. Now, Florida also tried to pass a bill that limited the amount of general damages that a person could have in a given case. That Supreme Court struck down the Florida statute as well. Now, they still do have, in fact, I was looking at it just today, they do have, and it has been allowed, a cap on the attorney's fees in some cases. It is, in fact, 33 1/3% of any recovery up to $1 million. It drops to 30% of any amount between $1 million and $2 million. And it drops to 20% on any recovery exceeding $2 million. So yeah, there are caps in various parts of the country. Right now, Georgia doesn't have any. So it's what a jury will do. But again, I hasten to add that standing behind the jury verdict, if a court determines that that verdict was excessive, then the court has the right to write the verdict down. In fact, we've recently had experience with that. The court will say, upon an appropriate motion, that they're going to reduce the verdict from X to Y, whatever it is.
Okay.
And you got to keep in mind, those verdicts are only recoverable if there is a deep pocket to go after, that there's insurance that covers it, or the defendant has adequate assets.
Okay, well, that would make sense. It would make sense. I have with us tonight Carl Reynolds and Wendell Horn, and they're answering your questions about catastrophic injuries and wrongful deaths. When we come back, we're going to deal with an automobile accident that went terribly, terribly wrong. So we're going to talk about that and a whole lot more. I'm Morgan Dukes, and you're watching LawCall. If you have further questions for Carl Reynolds or Wendell Horn, you can reach them both at Reynolds, Horn, and Savant right here in Macon. Their telephone number is 478-405-0300. You can also find them on the web at www.reynoldsinjurylaw.com. And don't forget to follow Reynolds, Horn, and Savant on Facebook. All right, gentlemen, we are back with more questions regarding catastrophic injuries and wrongful deaths. And our next question comes to us from Melanie. Melody sent in this question that she wants to know. She says, my neighbor and her 2 unborn babies were struck by a car in a grocery store parking lot. Now, the injuries caused her to go into preterm labor, and the driver of the other car hasn't been found. Have you ever heard of such a case like this? And what's going to happen to her? That's so sad, isn't it?
That's very sad. It's also a multi-part question that we could do a whole show on. But Wendell, why don't you try to take that one?
Well, the one thing that sticks out about that question is what we harp on over and over on this show and have for years, and that is uninsured motorist coverage. If they haven't found the driver, you've got to look towards your uninsured motorist, i.e. a John Doe unidentified driver, and that's the only coverage that protects you when you take out insurance. Now, there may be something to do with the construction or the layout of the parking lot that could have contributed to this accident that may be a defendant in the case. But short of that, not having that driver, you are going to be looking to your uninsured motorist coverage.
Okay.
And the quick answer to the other part of the question is, yes, they can all make a recovery as long as they have a viable defendant. That is both the unborn fetuses and the mother of the children.
Okay. Well, here's a question for you. What happens if you come across a case or even a client that you simply cannot work with for whatever reason? Well, how do you handle that?
Well, Morgan, as you know, we have set out about 10 questions that you should ask any lawyer who you would like to represent you. And we've also said on this show many times, if we can't help you, we will find somebody who can. To that point, we had a client come in with a potential medical malpractice case. It was a significant case with a very significant injury, a life-altering injury. Turns out that the offending physician, who simply made a mistake, committed an act of medical malpractice, but that same physician had had taken my daughter's tonsils out, and I had been to their practice several times myself. So I couldn't handle that case, but I was able to get a good, reputable, A-rated lawyer for this client who took it and actually went all the way through a trial with it and made an amazing recovery of $12 million on the trial of the case. And just in part related to my answer previously, that case after verdict was ultimately settled for significantly less than that, but almost half. So
Okay.
yeah, there are times we cannot take a case.
All right. But you, like you said, you do your very best to refer them to others.
We will find them a lawyer who is competent and good at what they do and refer them to that lawyer with no remuneration to this firm.
Okay. All right. Well, we do
Morgan,
yes.
It may be another type of case that we don't handle, like some class action mesh case. We send those to lawyers that do those all the time, toxic torts, domestic cases. So it's not just because we have a conflict. It may be an area of practice that we don't do.
Okay. And again, you want to remind everybody that you have a list of questions on your website. And if they have any questions whatsoever, they can always go there to see if it's something that you can work with.
Yes, and that they should do that. I mean, whether they come to us or somebody else, those are questions that you have a right to ask any lawyer you're about to hand your case over to.
Mm-hmm. And you do offer free consultations. That's important for a lot of people because they're wondering, how much is it going to cost me just to talk to an attorney?
We talk to people all the time. There's no charge.
Okay. All right. That's what we want to know. So if you have further questions for Carl Reynolds or Wendell Horn, you can reach them right here in Macon at Reynolds, Horn, and Savant. So make sure you give them a call, 478-405-0300. Gentlemen, it's been a pleasure to see you both tonight. It's always good to talk to you and get your advice. Until next time, I'm Morgan Dukes, and on behalf of all of us here at LawCall, good night, everybody.
Night.
Good night.